Indian Constitution, Article 5. Citizenship by domicile, Article 5. According to Article 5, a person is entitled to citizenship by domicile if he fulfills the following two conditions. Firstly, he must, at the commencement of the Constitution, have his domicile in the territory of India. Secondly, such person must fulfill any one of the three conditions laid down in that article, namely: 1. He was born in India. 2. Either of his parents was born in India. 3. He must have been ordinarily resident in the territory of India for not less than 5 years immediately before the commencement of the Constitution. Domicile in India is considered an essential requirement for acquiring the status of Indian citizenship. But the term domicile is not defined in the Constitution. The domicile of a person is in that country in which he either has or is deemed by law to have his permanent house. There is distinction between domicile and residence. Residence alone in a place is not sufficient to constitute the domicile. It must be accompanied by the intention to make it his permanent home. But it is basically a legal concept for the purpose of determining what the personal law applicable to an individual is, and even if an individual has no permanent home, he is invested with a domicile by law. There are two main classes of domicile: domicile of origin and domicile of choice. While the former attaches to the individual by birth, the latter is acquired by residence in territory subject to a distinctive legal system with the intention to reside there permanently. In Pradeep Jain vs. Union of India, the Supreme Court has held that in India Article 5 recognizes only one domicile, that is, domicile of India. It does not recognize the notion of state domicile. When a person who is permanently resident in one state goes to another state with intention to reside there permanently or indefinitely, his domicile does not change and he does not acquire a new domicile of choice. India is not a federal state in the traditional sense of the term. It has only one citizenship, that is, the citizenship of India. It has also one single unified legal system applicable throughout the country. The concept of domicile has relevance to the applicability of municipal laws, whether made by the Union of India or by the states. Two elements are necessary for the existence of domicile. 1. A residence of a particular kind, and 2. An intention of a particular kind. The residence need not be continuous, but it must be indefinite, not purely fleeting. The intention must be a permanent intention to reside forever in the country where the residence has been taken up. Domicile is not the same thing as residence. Mere residence in a place is not sufficient to constitute domicile. It must be accompanied by the intention to make it his permanent home. Thus, there must be both the factum and animus to constitute the existence of domicile, for neither domicile nor mere residence is sufficient to make him an Indian citizen. Domicile accompanied with 5 years residence are necessary to make a person a citizen. Thus, a person born in Goa of Goan parents came to Mumbai in his boyhood, was educated there, had resided there since then and did his father's business there. He was held to be an Indian citizen by domicile. In Muhammad Raza vs. State of Bombay, the appellant came to India in 1938. He pilgrimaged to Iraq in 1945. On return, he was registered as a foreigner and several times his stay in India was extended. In 1957, his request to extend the stay period was refused. He contended that he must be regarded as a citizen of India under Article 5, but his appeal was dismissed. The court held that though he was original resident, he did not acquire Indian citizenship because he did not have a domicile in India. When the appellant returned from Iraq, he took over the job of a cashier in a hotel. That by itself was held insufficient to establish that there was a change in his mind of the kind necessary to acquire a new domicile. His application for extending his stay in India made from time to time fortified this conclusion. The domicile of choice continues until the former domicile has been resumed or another has been acquired. In Louis D. Reid v. Union of India, the petitioners, who were foreign nationals, challenged the order of the central government expelling them from India on their failure to acquire Indian citizenship. The petitioners came to India before independence and were staying continuously on the basis of foreign passport and residential permits. They were engaged in Christian missionary work. They contended that they became citizens of India by virtue of Article 5(c) of the Constitution as they were staying in India for more than 5 years immediately before the commencement of the Constitution. The court held that they failed to establish that they had an intention to reside in India permanently. The petitioners did not have their domicile in India. For the acquisition of a domicile of choice, it must be shown that the person concerned had a certain state of mind, the animus manendi. If he claims that he had acquired a new domicile a particular time, he must prove that he had formed the intention of making his permanent home in the country of residence. Residence alone, unaccompanied by this state of mind, is insufficient. Domicile of origin is lost only on acquisition of domicile of choice and not on mere continuous stay in other country. A minor or married woman is not independent person. Neither of these classes has the legal capacity to make a change of domicile. Therefore, the domicile of an infant generally follows the domicile of his father, while a married woman takes the domicile of her husband. A widow retains the domicile of her husband until changed by her own act. Intention is an important element in determining the domicile of a person. It can be inferred from the conduct of persons. Thus, a person in government service, who was given the choice for opting for India or Pakistan, who opted for Pakistan, actually went to Pakistan, served there under the government of Pakistan, but who subsequently resigned his job there and came to India cannot claim the benefit of Article 5 for he never became the citizen of India.